Good day, Crime Talk aficionados. I have a great show for you today. First, now that the stage has been set for most of the issues in the Bryan Kohberger matter, let's make a case for guilt and innocence. Karen Reed is denied at the United States Supreme Court. Gosh, who said that was going to happen? Have some weird criminal celebrity news. Another teacher goes down this day in legal history. And just when you thought we couldn't find another dumb criminal of the day, we found one. Violated one of the oldest maxims in criminal investigations. Let's talk about it.
All right, lawyer.
Good day, everyone. My name is Scott Reich, and this is Crime Talk. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Leave me a comment below. Hit that little bell for notifications. And yes, check us out on any of your favorite podcasting apps. Now, yesterday, we really didn't do a big show. I gave you a summary of the, 6-7 hours of the Bryan Kohberger case. We're going to talk a little bit more about that since, the stage has been set. But before we do that, remember, go to CrimeTalkSearch.com. Sign up for that background subscription service today. And the beautiful thing about it is when you do, first of all, you can cancel at any time. Second, you can do as many searches as you desire while you have the subscription. And you are going to get a report prepared literally while you wait, and it will be emailed to you. And guess what? There are even updates are done if you request that and information changes. But that report is going to have information as to phone numbers, email addresses, social media presence, whether somebody has a criminal history. Do they have liens? Do they have judgments? Are they on one of those sex offender registries? Yes, the things that you want to check out about people coming into your life, or maybe you're not getting a warm, fuzzy feeling and you think, I need to get these people out of my life. So go to CrimeTalkSearch.com. You're going to be happy you did. All right. So like I said in the little teaser there, the Bryan Kohberger hearings took place yesterday. The judge had reserved the hearings to take place for today as well. There's still a couple of outstanding issues, but for the most part, most of the motions were resolved. We'll put a link to yesterday's show. And if you want to check it all out for yourself, just to make sure I'm not giving you the bum scoop, go watch the hearing in its entirety. I think I covered it all pretty darn accurate. And I'd like to say, if you go back and check out the live that we did Tuesday night, I predicted exactly what the judge was going to rule on everything that he did rule upon. So let's go ahead and take a look at this case. All right. Now, I understand you're going to say, Scott, you forgot about this. Scott, you forgot about that. I get it. Let me know in the comments what I am forgetting in the analysis. First, we'll do a case for why Bryan Kohberger is guilty. We'll also make a case for his innocence, and as it relates to the Bryan Kohberger as the guilty part, we'll kind of look at some of the coincidences that just happened to take place. All right. We'll obviously give him the presumption of innocence, which he is entitled to, but I'm pretty sure both the prosecution and the defense are thinking about these same things as well. And remember, this is based upon what we know. It can always change based upon new information coming about. And like I said, if I got something wrong, I'm sure you'll let me know. But that's okay. We want to make sure we get it right. And we get it right by hearing other people's ideas and having them submit the proof, so to speak. We're all about that. I'm a criminal defense attorney, have been for 30 years. I've had cases that have been great. And let's just say things have changed when new facts come in. I've had other cases I thought were going to be absolutely terrible, complete dead bang losers, and then something changes, a fact changes, and you get a very great result. So just something to consider as we go through this as well. So like I said, let's make a case for each since the stage has been set. First, obviously the murders of the 4 University of Idaho students, Kaylee Gonsalves, Madison Mogan, Zana Kernodle, and Ethan Chapin all took place on November 13th, 2022, and the subsequent investigation and legal proceedings involving Mr. Bryan Kohberger. Now, there's several coincidences that may tie into the narrative of him purchasing a knife, driving around, and leaving DNA, as well as other circumstantial factors that have raised questions or drawn attention. Now, we have kind of the pre-murder period, right? Going back to March of 2022, which is approximately 8 months before the murders, right? What is the event? Well, it's alleged that Bryan Kohberger, a then criminology PhD student at the Washington State University there in Pullman, Washington, allegedly purchased a K-bar knife. Now, we've heard some pretty good testimony. Even the defense basically admitted it yesterday, but, it was alleged that he purchased a K-bar knife, just like the one that I've had for the last 37 years right here. That's right, 37 years from the summer of 88 after I went to Marine Corps boot camp. Didn't have to get a new one after I finished Officer Candidate program either, but, you only need one, especially if you don't lose it. Anyway, so he purchased the K-bar knife, a sheath, and a knife sharpener from Amazon. Like I said, this is all according to documents filed by the prosecution. Coincidence. The purchase aligns with the type of K-bar knife sheath later found at the crime scene with Bryan Kohberger's alleged DNA on it. The timing, 8 months prior, raises questions about premeditation versus coincidental ownership of a common item for a criminology student interested in knives or perhaps maybe just self-defense. Then we have June of 2022. Bryan Kohberger completes his graduate studies at DeSalle University in Pennsylvania and moves to Pullman, Washington to begin his PhD program. And coincidentally, that's just 10 miles from Moscow, Idaho. Coincidence. His relocation places him in close proximity to the eventual crime scene, though this could be explained by the academic pursuits rather than intent. Then we have the summer and fall of 2022. What's the big event there? Well, Kohberger's cell phone pings near the victim's residence at 1122 King Road in Moscow on at least 12 occasions prior to November 13th, 2022, mostly late at night or early in the morning, according to the probable cause affidavit, right? That was unsealed back in January 2023. Coincidence? He just happened to be driving around or near the victim's home multiple times in the months leading up to the murders, despite not having a known connection to the victims. His later alibi of enjoying the late night drives to look at the moon and stars aligns with this pattern, but strains credulity given the frequency and location. Then in August of 2022, Kohberger is pulled over in a traffic stop by the Moscow police, during which time he provides his phone number, which later aids investigators in tracking his cell phone activity. What's the big coincidence there? He just happened to interact with local law enforcement months before the crime, providing a traceable link that would later assist in identifying him as a suspect. Then we have the night of the murders, November 13th of 2022, right? That evening, 9 p.m. to 1:45 a.m. The events there. Victims Ethan Chapin and Zaina Kernodle attend a party at the Sigma Chi fraternity, while Kaylee Gonsalves and Madison Mogan are seen at a food truck in Moscow about 1:45 a.m. This is all per surveillance footage. Then, to give a little context, the victims returned to their off-campus home at the 1122 King Road address, where two surviving roommates, Dylan Mortensen and Bethany Funk, are also present. And then, at approximately 2:47 a.m. to 4 a.m., a white Hyundai Elantra, later linked to Bryan Kohberger, is captured on security footage leaving Pullman, headed towards Moscow, and returning about 5:30 a.m. per the arrest affidavit. What a coincidence. Kohberger just happened to be driving his car, a 2015 white Hyundai Elantra, near the crime scene during the early morning hours when the murders occurred. Well, and this just happens to match up his stated habit of late night drives, but aligns suspiciously with the timeline of the killings. Then at approximately 4 a.m. to 4:25 a.m., the murders allegedly occur. Well, they did occur. It's just alleged who may have done it, right? Kaylee Gonsalves, Madison Mogan, Zaina Kernodle, and Ethan Chapin are stabbed to death in their beds with a large fixed knife, aka a K-bar. A knife sheath is left on the bed next to Mogan's body, containing a single source of male touch DNA that is later matched to Bryan Kohberger. What a coincidence. Bryan Kohberger just happened to leave behind a knife sheath with his DNA on the button snap at the crime scene. Just happened to be there. For a criminology student, presumably aware of forensic evidence, this seems an extraordinary oversight, unless perhaps he was intentional or perhaps He panicked. And just think of the coincidence, ladies and gentlemen, of all the people in the world, right? This is what the prosecution is going to argue. Of all the coincidences in the world, his single source DNA just happened to be on the little button here or inside. Doesn't really matter. It's there. Think about it. Is your DNA there? Did your DNA just happen to be there? Was mine there? No, it wasn't. What are the odds? It just happened to be Bryan Kohberger's DNA on the knife sheath. Just something to think about. Right? Then at approximately 4:20 a.m., the surviving roommates, Dylan Mortensen, hears noises, including crying, and sees a masked man wearing black clothing with bushy eyebrows leaving the house. She locks herself in her room, but does not call 911 until hours later. Now, the description, the coincidence here is the description vaguely matches Kohberger's appearance, and he just happens to be seen by a witness, adding another layer of circumstantial evidence. Then at 4:48 a.m., Kohberger's cell phone, previously turned off during the murder window, pings again at State Highway 95 south of Moscow, consistent with the white Hyundai Elantra's movement. Coincidence there? His phone just happened to go silent during the critical time frame, only reactivating as he allegedly fled, a tactic that could suggest planning, but also conveniently aligns with his driving alibi. Perhaps. Then we have the post-murder investigation, right? Between November, from the date of the murders, to December of 2022, right? November 29th. Police identify a 2015 white Hyundai Elantra registered to Bryan Kohberger at the Washington State University through a vehicle search, linking it to the car seen near the crime scene. What a coincidence. He just happened to own a car matching the description and movements captured on video, obviously further tying him to the crime scene. Then we have mid-December of 2022. The FBI uses the investigative genetic genealogy to analyze the knife sheath DNA, building a family tree, and points, coincidentally, to Kohberger. This leads to surveillance of him in Pullman and ultimately on his way to Pennsylvania and in Pennsylvania. Coincidentally, his DNA just happened to be traceable through public genealogy databases, an advanced technique that bridges the gap between traditional CODIS searches, which failed. Then, between December 15th and 17th of 2022, Bryan Kohberger drives cross country from Pullman to his parents' home in Albrightsville, Pennsylvania, with his father. They're pulled over twice in Indiana for tailgating, allowing police to observe his hands for injury. None noted. Coincidence. He just happened to leave Idaho shortly after the murders, potentially distancing himself from the crime scene, though this was framed as a planned holiday trip. Trying to keep it fair and balanced, ladies and gentlemen. And then on December 27th, 2022, Pennsylvania police recover trash from the Kohberger family home. DNA from the trash matches the biological father of the person whose DNA was on the knife sheath with 99.99998 certainty per the arrest affidavit. Coincidence there? His family just happened to discard trash containing DNA that could be linked back to the crime scene, providing a critical confirmation of the IGG findings. Then on December 30th, 2022, Kohberger is arrested in a pre-dawn raid at his parents' home in Pennsylvania. Items were seized from his apartment, including a pillow with a reddish-brown stain, gloves, and hair strands. Coincidence? He just happened to have potentially incriminating items in the possession through their direct connection to the murder remains circumstantial without further testing, and we just don't know that just yet. Then we have the legal proceedings beginning January 5th of 2023. The probable cause affidavit is unsealed, detailing the DNA on the knife sheath, cell phone data, car movements, and Mortensen's eyewitness account. Coincidence? Multiple pieces of evidence just happened to converge on Kohberger, painting a somewhat compelling but still circumstantial picture. Then May of 2023, specifically May 22nd, Kohberger stands silent at his arraignment. A not guilty plea is entered on his behalf, which is frankly not that unusual. And then the prosecutors have 60 days to decide on whether they're going to seek the death penalty, which they ultimately do. His refusal to plead not guilty could reflect strategy or defiance, but it doesn't alter the evidence that's obviously coming up against him. Then on June 21st of 2023, prosecutors filed documents stating that the knife sheath DNA is 5.37 octillion times more likely to be Kohberger than an unrelated person based on a cheek swab taken after his arrest. What's the coincidence there? The statistical match is extraordinarily precise, and yet the defense later questions the IgG process and suggests possible planting of the DNA. Now, of course, we heard at the motions hearings, no one's going to be mentioning the investigative genetic genealogy, and the defense doesn't want to go there at all. Then, in October of 2023, Kohberger waives his right to a speedy trial, delaying the original October 2023 trial date to allow more preparation time. He provides an alibi, driving alone to look at the moon in the stars. Coincidence there? His alibi just happens to involve driving on a night when the weather reports indicate it was rainy and overcast, undermining its plausibility. Then in May of 2024, the defense formally submits the driving alibi, claiming phone data analysis will corroborate his location away from Moscow. Prosecutors challenge the vagueness of this alibi. Now remember, the alibi just happened to rely upon data that conflicts with earlier cell phone pings near the crime scene. Then on February 20th, 2025, Judge Hippler denies the defense motion to suppress the knife sheath DNA and digital evidence, which include Google, Amazon cell phone data. Obviously, these rulings are that Kohberger had no expectation of privacy to the abandoned DNA or third-party records. Well, what's the coincidence there? The judge just happened to uphold the prosecution's key evidence, thwarting a major defense strategy. Then on March 4th of 2025, the defense reveals DNA from 3 individuals under Madison Mogen's fingernail, with Kohberger's comparison deemed inconclusive. They also note blood from 2 unknown males at the scene on a handrail and a glove. Coincidence there? Well, other DNA just happened to be present, potentially supporting an alternate perpetrator theory, though it doesn't negate the knife sheath evidence. Then on March 19th, 2025, new filings confirm Kohberger's Amazon purchases of the K-bar and the sheath. Prosecutors allege the defense will claim the sheath was planted. What a coincidence. The purchase just happened to match the exact item found at the scene, though the planting theory introduces a counter narrative, I guess. Then on August 11th, 2025, Kohberger's trial is scheduled to begin in Ada County. Now that assumes there isn't going to be some plea or a possible continuance of that as well. So to summarize, the case remains poised on the knife sheath, the DNA, the driving patterns, and circumstantial evidence with coincidences fueling both sides' arguments. Now, the key coincidence in the case obviously is the knife purchase, right? Kohberger just happened to buy a K-bar knife and the sheath just months before the murder, matching the sheath found at the scene with the DNA. Criminology student owning such an item could be completely plausible. But the exact match is, well, it's somewhat striking. The driving around, he just happened to be driving near the victim's home 12 times prior to the murder on the night of the crime, as evidenced by cell phone and car data. His alibi of stargazing on a rainy night strains belief given the timing and location, and the DNA on the knife sheath just happened to leave his DNA on the sheath at the crime scene, an apparent blunder for someone with forensic knowledge. The defense planting theory suggests it just happened to be placed there by somebody else. Then we have the cell phone activity. His phone just happened to go silent during the murder window, only reactivating as he left the area, a pattern that can suggest planning but aligns with his driving narrative. Eyewitness sightings. He just happened to be seen by a roommate whose description loosely fits him, adding a human element to the forensic evidence. And then we've got the trash DNA match. His family just happened to discard trash and DNA linking back to the sheath, providing the second confirmation that kind of sealed his arrest. And then we have other DNA on the scene. Unknown male DNA just happened to be found elsewhere, fingernails, handrails, gloves, offering the defense a chance to argue someone else was present, though it doesn't directly contradict the sheath evidence. Now, the analysis of coincidence here formed the backbone of the prosecution's case, obviously portraying Mr. Kohberger as either a calculated killer who made critical errors or an unlucky individual just happened to be caught in a web of circumstantial evidence. The defense counters these theories of planted evidence, investigative bias, and an alibi that hinges on his quirky habit of night driving, which basically the judge said yesterday, I don't foresee an alibi instruction coming in. So the sheer number of just happened moments, especially the knife purchase, the driving patterns, and the DNA, suggests either remarkable misfortune for Mr. Kohberger or a series of incriminating actions that defy random chance. As of today, the trial outcome will likely hinge on how the jury interprets these coincidences against the forensic and circumstantial evidence. Now, since we give both sides of it, and frankly, any defense attorney should be able to argue both sides of any case, because frankly, you're constantly doing that as an attorney. This is what their side did. If I was on that side, I'd be doing this. So let's make a case for Bryan Kohberger's innocence in the murder of Kaylee Gonzalez, Madison Mogen, Zainer Kernodle, and Ethan Chapin, based on the available evidence and developments that we have up to the motions hearing as of yesterday. Now, this argument is constructed by highlighting gaps in the prosecution's case, emphasizing alternative explanations for evidence, and leveraging reasonable doubt without definitively proving innocence, as that's not possible without a new exculpatory evidence. It aligns with the defense strategies and public filings while remaining grounded in the known facts. All right, here we go. Hold on, ladies and gentlemen. The case for Bryan Kohberger's innocence. First, a lack of any direct evidence linking Bryan Kohberger to the crime scene. There's no direct physical evidence such as blood, fingerprints, or eyewitness testimony placing Bryan Kohberger inside the house at 1122 King Road during the murders. The prosecution relies heavily on a single piece of touch DNA evidence on this K-bar knife sheath found near Madison Mogen's bed. However, this DNA does not prove Kohberger was present at the time of the crime. It only shows he handled the sheath at some point. No murder weapon's been recovered, and no blood from the victim was found on Bryan Kohberger in his car or at his apartment, despite the brutality of the stabbings, which likely would have left significant trace evidence on the perpetrator. Now, the surviving roommate, Dylan Mortensen, saw a masked man with bushy eyebrows, but could not positively ID Bryan Kohberger. Her description is vague and could apply to many individuals, undermining its reliability as a link. Reasonable doubt, ladies and gentlemen. Without definitive proof of Bryan Kohberger's presence during the murders, the prosecution narrative hinges on circumstantial inference rather than fact, leaving room for alternative perpetrators. Then we have the knife sheath DNA. It could have been planted or transferred argument, right? The defense has suggested the possibility that the knife sheath was planted or that Bryan Kohberger's DNA was transferred to it innocently, challenging its role as a smoking gun piece of evidence in this case. Now, this touch DNA, skin cells, can persist on objects for months and transfer through secondary contact. Kohberger, as a criminology student, might have handled a sheath like this during academic exercises, at a store, or in casual interaction, and it could have ended up in somebody else's possession. Then on March 19th of 2025, the filings confirm Bryan Kohberger's Amazon purchase of a K-bar knife and sheath does not prove it's the same sheath found at the scene. K-bar is a popular brand, and multiple identical sheaths exist. The defense planting theory persists that someone else used the murder to frame him, placing the item linked to him at the scene. Now, the absence of Kohberger's DNA elsewhere in the house, example on doorknobs, walls, or on the victim itself, is quite notable, given the chaotic nature of the attack. If he left the sheath, why is there no other trace of him? Reasonable doubt, ladies and gentlemen. Now, the prosecution cannot conclusively rule out contamination, transfer, or planting, especially since investigative genetic genealogy led by police to Kohberger earlier potentially biased their focus and their evidence collection. Then we have the presence of other DNA suggests an alternative perpetrator. DNA from 3 different individuals was found under Madison Mogen's fingernail, with Kohberger's comparison deemed inconclusive. And blood from 2 unknown males was identified at the scene, on the handrail and on a glove. That's all per the defense filings. Now, this evidence suggests Others were present or potentially involved. And potentially, they were the actual killers. Now, the fingernail DNA could indicate that Mogen fought her attacker, yet it doesn't match Bryan Kohberger definitively. The prosecution has not explained the unidentified DNA profiles, focusing fully on the sheath. If multiple people were in the house, the narrative of a lone killer, Bryan Kohberger, becomes quite less possible. The defense could argue that the police latched onto Kohberger due to the sheath's DNA and neglected to pursue other leads, such as these unknown males. Reasonable doubt, ladies and gentlemen. The presence of other DNA introduces a viable alternative theory. Someone else committed the murders, and Kohberger's DNA on the sheath is simply coincidental or planted. Now, Kohberger's alibi and driving patterns are plausible, according to his attorneys, right? His alibi that he was driving alone to look at the moon and the stars on November 13th is consistent with his habits and doesn't inherently implicate him in the murders. We got this cell phone data showing his phone near 1122 King Road on 12 prior occasions on the murder night, aligned with his claim of enjoying late night drives in rural areas near Pullman and Moscow. And as a student with an interest in criminology, he might have been drawn to the area of curiosity or routine, but nothing with malice intended. The prosecution notes his phone was off from 2:47 to 4:48 a.m., implying he silenced it during the murders. However, this could have reflected a dead battery, poor signal in rural Idaho, or a habit of conserving power, none of which proves criminal intent, ladies and gentlemen. Now, the weather reports of rain and overcast skies on November 13th don't disprove his alibi. He could have been driving for solitude or to clear his mind, not strategizing any type of malintent or murder. Reasonable doubt, ladies and gentlemen. Without video or witnesses placing him at the house, his driving patterns are circumstantial and could reflect an innocent routine rather than stalking or fleeing a crime scene. The white Hyundai Elantra is not unique. That 2015 Hyundai Elantra has seen near the crime scene and registered to Kohberger is not definitive proof of his guilt, as it is a common car model. Surveillance footage shows a white Elantra moving towards and away from Moscow, but the license plate is invisible, and no witnesses saw Kohberger driving it near the house at the exact time of the murders. Thousands of similar cars exist in the region, and police initially sought tips of any white Elantra, not just Kohberger's. His ownership could be coincidence, exploited by investigators once they focused on him via the DNA. That's reasonable doubt, ladies and gentlemen. The car evidence is associative, not conclusive, and doesn't prove that he was, in fact, the driver or at the scene during the critical window the prosecution alleges. Then we've got investigation bias and tunnel vision. The police and the FBI have prematurely zeroed in on Kohberger, overlooking other suspects due to the IgG DNA match and his proximity as a student at Washington State University. Now, the use of this IgG to build a family tree from the sheath DNA to Kohberger's within weeks, potentially skewing the investigation. Once they had a suspect with a matching car and a criminology background, confirmation bias could have shaped their interpretation of the circumstantial evidence. For example, the cell phone pings, Amazon purchases. Now, the defense has challenged the IgG process reliability and legality, arguing in motions that were denied that it violated Kohberger's privacy and may have produced flawed results. Now, if the initial DNA lead was shaky, the entire case could unravel. But we know that now the defense isn't going to do that, so we'll leave it at that. But Kohberger's academic focus on crime and his socially awkward demeanor might have made him an easy target for profiling rather than a genuine suspect. Reasonable doubt, ladies and gentlemen. A biased investigation could have missed the real killer, pinning the crime on Kohberger due to a convenient but incomplete narrative. Character and lack of motive. Kohberger has no known connection to the victims, no criminal history, and no apparent motive, weakening the prosecution's case. Now, unlike typical murder cases, there is no evidence of personal animosity, romantic entanglement, or financial gain linking Kohberger to Gonzalez, Mogen, Kernodle, or Chapin. Next, let's take a look at his character and lack of motive. Bryan Kohberger has no known connection to the victims, no criminal history, and no apparent motive. Obviously, that could weaken the prosecution's case. And unlike typical murders, there's no evidence of personal animosity, romantic entanglement, or financial gain linking Kohberger to Gonzalez, Mogan, Kernodle, or Chapin. The prosecution suggests a random thrill kill, but this is speculative and unproven at best. Now, as a criminology student, Kohberger was studious and reserved and not a violent outlier. His academic interest in crime could explain his knife ownership and late night drives as intellectual curiosity, not preparation for murder. Reasonable doubt, ladies and gentlemen. Without a motive, the prosecution's story lacks a psychological anchor, making it hard to convince a jury beyond a reasonable doubt. Then we have the timeline and logistics that raises big issues. First, the tight timeline and physical demand of the murders cast doubt on Kohberger as a lone actor. The murders occurred between 4 a.m. and 4:25, with Kohberger's phone pinging of Moscow, Idaho at 4:48 a.m., committing 4 stabbings across 2 floors, escaping undetected, and driving away in under 48 minutes requires precision and stamina. Yet no injuries or exhaustion were noted during his Indiana traffic stop just 2 weeks later. The chaotic scene, multiple victims, blood, evidence everywhere, contrasts with the clean getaway implied by the lack of victim DNA on Kohberger or his belongings. Reasonable doubt, ladies and gentlemen. The logistics suggest either multiple perpetrators or a different timeline, neither of which firmly implicates Bryan Kohberger. So, what does this mean? Innocence. Bryan Kohberger could have been an innocent man caught in a perfect storm of circumstantial evidence. He owned a common knife and sheath, as many do, right? I've got one. And his DNA ended up on an item that was either misplaced, transferred, or planted at the scene. His habit of late night drives near Moscow, a small college town close to his university, was misinterpreted as stalking, and his white Elantra, one of many in the area, became a convenient match. The presence of other DNA suggests an alternative killer, while investigative bias locked onto Kohberger due to his academic background and a single forensic hit. Without direct evidence, a clear motive, or definitive eyewitness, the prosecution case rests on shaky foundation of what ifs rather than what is. In conclusion, Kohberger's innocent doesn't prove he didn't commit the murders. It argues that the prosecution evidence as the April 10th hearing fails to eliminate reasonable doubt. Remember, the defense need only convince a jury that another explanation is plausible, and the gaps in the narrative, the unexplained DNA, a questionable sheath, a lack of direct ties provides that opening. Whether this holds up at trial obviously depends on how effectively the defense can exploit the weaknesses and the counters the prosecution's somewhat compelling argument. But, ladies and gentlemen, hopefully you can see we laid out the case for guilt and the case for not guilty for Bryan Kohberger. We should all be looking at it on both sides and say we need to reserve judgment until we hear all the facts in the case. Base our decision based upon legal and competent evidence that is admitted at trial. And hopefully you'll see that a good attorney can make an argument for both sides. That's what attorneys are supposed to do. And we can come up with arguments for both sides. Next on the docket, Karen Reed. The jury selection resumed Thursday in the trial for Karen Reed, with one additional juror needed to round out the panel of 16 jurors. 3 more jurors were selected on Wednesday, bringing that tally to 15, and 4 of the 16 jurors will serve as alternates. Well, Reed has pled not guilty to the charges of second-degree murder, manslaughter while operating under the influence, and leaving the scene of a personal injury and death. Obviously, the prosecutors allege the former financial analyst and adjunct professor backed her Lexus SUV in a drunken rage into her boyfriend, then Boston police officer John O'Keefe, back on January 29th of 2022, after dropping him off outside of a home following a night of bar hopping. Her lawyers, however, say that she's been framed and that O'Keefe entered the house owned at the time by a fellow Boston police officer, where he was fatally beaten, possibly mauled by the house owner's German Shepherd, before his body was thrown into the cold and planted to frame Karen Reed. Obviously, the first trial ended in mistrial, and we're getting the jury as well. And also, as predicted, on Wednesday, the United States Supreme Court denied her request to pause the retrial while it decides whether to take up her case on appeal, that the murder and leaving the scene charges against her should be dropped. The state's Supreme Judicial Court and the federal courts in Massachusetts have declined to drop the 2 counts, which the defense requested after multiple jurors indicated that they, in fact, unanimously agreed to acquit her of those charges, remaining divided only on the manslaughter charge. Didn't expect that to go anywhere, but I guess when you have a legal defense fund like Karen Reed does, you pull out all the stops. Seems like a lot of money spent on something that everybody, if you were being intellectually honest, knew was going nowhere. Now, one thing I want to mention, and I was doing some research because I've always said from my own personal experience, the defense never does better on a retrial because the prosecution gets to fix their case. I guess the defense can kind of fix their case, but they usually got one theory and they've got one shot at it. That's been my experience, and it usually doesn't end well for the defense. Now, obviously, when the jury is deadlocked, the prosecution often retries a case if they believe the evidence is strong. Now, there are some studies that suggest acquittal rates in retrials after hung juries are just slightly higher than in the initial trial because the defense can adapt its strategy based upon the first trial's feedback. However, conviction rates remain high, often 60 to 70%, since prosecutors typically pursue retrials when they think they can win. And guess what? They too get to fix their rate, their case as well. Now, across U.S. jurisdictions, criminal trial results result in about 70 to 85% conviction rates that goes to trial, and retrials tend to follow a similar pattern with conviction rates estimated between 60 to 80%, obviously depending on the case, the type of case, jurisdiction, and the acquittal odds for defendants in retrials are generally between 20 to 40%, though it's not exactly an exact science, given there's so many things that cannot be controlled. Next, we got a little celebrity true crime news. We're learning more about the police shooting involving Jillian Lauren Schreiner, wife of Weezer bassist Scott Schreiner, in LA this week, and she's been released on a $1 million bond after allegedly firing a single shot and being charged with attempted murder. We're learning more from police scanner audio, which provides some insights into Tuesday's shooting with the police. From the recordings, you can hear officers on the ground and helicopters flying overhead, coordinating a response to a search for a male suspect who apparently stripped down to his boxers and dove into a pool in an attempt to throw the officers off the chase. Now, Jillian was shot by police when she emerged from her house with a gun in hand as the male suspect prowled her next-door neighbor's backyard where the police were located. Now, the California Highway Patrol and the Los Angeles Police Department officers responded to a hit-and-run crash, and one of 3 of the suspects ran from the scene into the surrounding Eagle Rock neighborhood and into the backyard next door to the Schreiner's house. Jillian allegedly came out of her house with a gun in hand, and cops searching for the suspect, allegedly that she pointed her weapon at them. And police say that Jillian ignored multiple commands to drop the weapon. And then law enforcement say that they fired one shot. At least one officer fired at her, striking her in the shoulder. And she was being treated for non-life-threatening gunshot injuries. And they arrested and booked her on attempted murder charges. And like I said, she had a bond of $1 million that she posted. Now, her apparently famous husband, Scott Schreiner, was not home during the incident. And police said that they recovered a single 9mm handgun at the house. Now, the original suspect was arrested at the scene, and 2 other suspects remain at large. All right, I'm going to say it. Another teacher goes down. Another teacher misbehaving. Yes, that's right, ladies and gentlemen. I got a lot of people said, why do you criticize teachers so much? I'm not. They just keep continuing to commit crime, ladies and gentlemen. Please meet Emily Nutley. She will now be a Tier 3 sex offender on the Ohio Sex Offender Registry, which is the highest designation. And that means that anyone living within 1,000 feet of her home will be notified about her sex offender status. They're actually going to send postcards to the neighbors informing them of who Miss Nutley is and the sex crimes for which she was convicted, namely 2 counts of sexual battery after being accused of having a sexual relationship with a student at the St. Xavier High School in Cincinnati, where she was a guidance counselor. She was given some guidance, wasn't she? Anyway, Nutley's sex offender status also means she needs to check in with police every 90 days for the rest of her life. Now, Miss Nutley apparently is also becoming a sex offender, is also going through a divorce that her husband filed to end the marriage only weeks after prosecutors indicted her for having a sexual relationship with a 17-year-old student. She pled guilty just the other day. I don't know. I'm just telling you, Miss Nutley is going to show up on CrimeTalk search databases once she's finally sentenced. You know, obviously she's not presumed innocent anymore. She pled guilty, but we'll see if she actually goes to prison when sentencing comes around. Next, on this day in legal history, on April 10th, 1790. That's right. We went way deep into the CrimeTalk legal history files. Congress approved the U.S. First Patent Act. The Patent Act of 1790 allowed inventors to maintain sole and exclusive right and liberty of making, constructing, using, and vending to others a patented invention for 14 years. The act furthermore created the U.S. Patent Board, the precursor for the modern U.S. Patent Office. On this date, April 10th, 1960, the Civil Rights Act of 1960 is signed into law by President Dwight D. Eisenhower, obviously strengthening voting rights enforcement and addressing racial crimes through its passage. Then on this date in 1981, President Ronald Reagan returns to the White House after surviving an assassination attempt on March 30th, prompting discussion on gun control laws and, also Secret Service protocols that didn't quite go as planned, right? I remember that I was in grade school and they sent us home for that. Remember like it was yesterday. I remember watching it over and over again thinking, I want to be a Secret Service agent. Wouldn't that be cool? And then on this date in 2001, April 10th, 2001, the United States Supreme Court heard arguments in Kelo versus United States, which was decided later in June, establishing Fourth Amendment protections against thermal imaging surveillance, which means they can't use thermal imaging to see what the heck you're doing inside your house. So if you got a big pot grow or something, they can't use thermal imaging. Got a little bit of expectation of privacy. Then on this date in 2008, the United States Supreme Court hears argument in the case of District Court versus Heller that ultimately decided in June of that year that impacted the Second Amendment interpretations and gun crime laws. And just when you thought we couldn't come up with another dumb criminal contestant of the day, we did it. A prolific Walmart shoplifter has finally been caught after stealing more than $20,000 worth of merchandise. Now, it was not his sleight of hand, but his hilarious name that grabbed the headlines. That's right. His name is Speedy Gonzalez. That's right. His name is Speedy Gonzalez. He was caught on surveillance camera stuffing an empty trash can full of other goods and then scanning just the trash can as he left the self-checkout aisle at a Walmart in Gainesville, Florida. His tactic seems to be the latest variation of the infamous banana trick used by shoplifters. That's when a shopper takes a more expensive item and rings it up as bananas and other cheap items at the self-checkout stand. Now, Mr. Gonzalez allegedly stole from the store more than 20 items before ultimately being caught by the police. But after viewing the security tape, which showed Gonzalez stealing nicotine products, gum, diabetic test strips, and other high-priced items, police waited for him to return 10 days later and caught him in the same act. After searching his car, guess what? The police found stolen merchandise that obviously linked him to the string of heists across North Georgia. Guess what? It's not his first rodeo. He has an extensive rap sheet for shoplifting. And the criminal has also been caught stealing cashing checks for at least $3,000 worth of goods at Home Depot. And they discovered those checks had been stolen from a mailbox in a suburb of Atlanta. Nice, Speedy. Anyway, Speedy was booked into the Hall County Jail in Gainesville before being moved to a nearby jail in Barrow County, where he's being detained on felony charges. Now, this is a teachable moment, ladies and gentlemen. Pigs get fat, hogs get slaughtered. Couldn't just shoplift from once, right? No. You couldn't just do one and get away with it and say, I'm good to go. The school principal the other day that said, I just wanted to try it. Everybody's doing it. I want to be one of the cool kids, right? Well, Speedy Gonzalez, though, here does it multiple times. It's multiple location. Pigs get fat, hogs get slaughtered. Speedy, remember that. And the old adage that investigators always use, the criminal always returns to the scene of the crime. Speedy, they were waiting for you, buddy. Don't do that anymore. Don't take other people's things, even if it's Walmart. I don't care if it's a little old lady on the street corner or a multinational corporation. Don't steal things, ladies and gentlemen. All right, that's all we have for you today. Thanks for watching. Hope you enjoyed the show. We'll see you tomorrow. And remember, the Constitution matters.